This is EWU Media LLC versus the City of Moscow, the Moscow Police Department. This is CV 2926162. Looks like I have Ms. James with EWU Media LLC. Ms. Kennedy is appearing here on Zoom on their behalf. And then I have Ms. Batista appearing on as the Moscow City Attorney for the City of Moscow. Ms. Brereton and Mr. Jones appearing on behalf of the City of Moscow and the Moscow Police Department. Mr. James appearing here on Zoom on behalf of the interveners in this matter, Ms. Karen Laramie and the Chapins. This is the time set in the case for oral argument on EWU's petition. In anticipation of the proceedings here today, just as to recap, this is a petition for disclosure of public records, which EWU has sought from the City of Moscow related to the Koberger matter. And the petition was filed on February 20th of 2026. Court did set an initial hearing on the matter. And then following that, we set a briefing schedule and oral argument. The petitioner's brief, Ms. Kennedy filed that brief on March 30th of 2026, along with the declaration of Ms. James, for which the court has reviewed. Court has also reviewed the request to take judicial notice of CV 2925755, the memorandum decision granting in part the plaintiff's complaint for permanent injunction entered in that matter on October 1st of 2025. There then was, the court reviewed Mr. James's memorandum in opposition filed on behalf of the interveners. In this case, the declaration of Mr. James, Leander James. I want to be clear, my understanding is Ms. James from EWU, Mr. Leander James, not related, representing or appearing for two completely different parties in this matter. I have also reviewed the response from the City of Moscow filed by Ms. Brereton, the declaration of Ms. Brereton. And then subsequent to that, there was a reply filed by Ms. Kennedy. Again, a declaration of Ms. James. And then there was a motion to continue that's been filed by the city. Mr. Jones, Ms. Brereton filed that motion to continue. The oral argument on the substantive issue of the public records request. Declaration of Ms. Batista was filed in support of that motion to continue, and then court has also reviewed Ms. Kennedy's objection. Before we proceed with oral argument, I would note here for the record that we do not have a court reporter today. This matter is being recorded through the FTR system, but due to a shortage in court reporters in our district, our court reporters are currently in other courtrooms and unavailable for this particular proceeding. So I do need to ask Ms. Kennedy on behalf of the plaintiff in this matter, are you agreeable to waiving the requirement of the court reporter here today?
We are, Your Honor. Thank you.
And then Mr. Jones or Ms. Brereton, I'm uncertain which one of you will be arguing today, or maybe both.
I will be doing most of the argument today, Your Honor. And with respect to the limited question of the court reporter, we have no objection to that.
Okay. Mr. James, on behalf of the interveners, are you agreeable to waiving the requirement of the court reporter?
We are agreeable, Your Honor. Thank you.
All right, so based upon that, that requirement will be waived pursuant to the rules for this proceeding. We will go ahead then and take up the first issue, which is the motion to continue that's been filed by the city. So, Mr. Jones, if you wish to proceed on that matter.
Thank you, Judge. Your Honor, what we're asking the court to essentially do today is address the procedural issue of the petitioner's standing and capacity to bring this lawsuit, but however to not address the substantive issues. And if the court finds that the petitioner does have essentially standing to bring this lawsuit, then we would ask that the court continue the substantive issues for an opportunity to fully brief this. This is largely a judicial economy and interest of justice argument in the sense that we have This is essentially a 12B6 motion in that no matter what the petitioner, no matter the merits of the case, they cannot prevail because they haven't registered to do business within the state, and so they don't have access to the courts. And it shouldn't be the city's obligation to incur the costs of litigation and so on if the petitioner cannot prevail on the arguments requested. And so with that, I think that it's in the interest of justice for the court to grant this continuance in this fashion. And then I think most importantly, this is a matter of significant consequence. And I think that the court and the public deserve a fully complete record. This bell can't be unrung. And so once the city does disclose these records, these records are out there. And so I think that it does have a certain amount of interest to the public and the city and the petitioner to fully brief this and fully allow the parties to develop their arguments. And so with that, Judge, we're asking the court to structure its decision in that fashion.
Mr. Jones, I do have a question. I mean, understanding the city's argument with regard to this threshold inquiry, even if the court were to find that EWU was transacting business in the state of Idaho such that it should be registered as a business with Secretary of State's office in the state of Idaho, it has done so now, given the city's argument. So does that not make the issue moot at this point in time? What more would you be requesting as far as any kind of, I guess, court ruling or remedy on that issue?
So with respect to that, Your Honor, we don't feel that that necessarily cures the position of the petitioner by registering. At the risk of getting into that particular argument, it's our position. First of all, I would object to that declaration on May 1st as the fact that it's hearsay. The rules of evidence apply to this hearing. I can get into that objection a little bit more. And so I'm not sure that for the purposes that that's properly before the court. And then in any event, the case that the petitioner cites to essentially argue that they can cure the defect and register anytime prior to judgment, that's that analyzes a different statute. It's a 1968 case, and it considers contracts. And so essentially the question that was before the court in that case, and that's Twin Harbors Lumber versus Carico. The question that was before the court in that case was, should a contract be voided? And so we aren't necessarily conceding the fact that because they've registered, they now have standing. However, that does, for the purposes of the motion to continue, that does materially change the posture of it as well. And so because now they are registered. And so that would be our position there.
Well, I guess I'm trying to understand then, because your briefing on this issue, well, let me back up. So the city had an opportunity. Obviously, there's a couple of things that are going on. So first of all, court set the underlying issue on the petitions for public records request for this particular argument. In that period of time, when the court set the briefing schedule, the city elected to, in its response, file a response which essentially could have been filed as a motion to dismiss in a sense, but on this particular issue, and not respond to the substantive argument regarding the public records issue. And so I don't have any information from the city on that, which I understand your argument to be, you want the hearing to be bifurcated. But what I'm trying to figure out is, in your response, in the city's response, when it took the position of that EWU needed to be filed, because I'm reading it as there, you argue, the city argues, EWU is a foreign filing entity doing business in the state of Idaho, and so it must be registered with the Secretary of State's office to maintain an action in the court. Is that right, Mr. Jones?
Yes, Judge.
Okay. So they're now registered, or even if they are registered, well, let me ask, do you disagree with that?
I mean, for the purposes of the evidence, like the hearing, we're going to object to the introduction of that evidence, but I don't disagree with the fact that it appears that they've been properly registered. I want to just use my words carefully there. I'm not going to challenge that necessarily.
Okay. So would the remedy be, so let's just say the court were to find that they were a foreign entity doing business in the state and they weren't registered. If that were the court's findings, then the city would be asking that this be dismissed. Right?
Correct.
Okay. But then my question is, so if that were the case and the court were to order it to be dismissed and then they do register, which we believe it appears they have. So if setting aside the rules of evidence, I understand. So then they could refile, right? Impose it. And so we would be back in the same position of arguing the substantive merits. Is that right?
Yes, Your Honor. And I guess in a nutshell, I mean, if the court finds that registering cures the defect for the purposes of this petition, then continuing it would satisfy the interest of justice, because then the city would take the opportunity to respond to the merits of it. Now, a couple of things that would change. Should the court dismiss the petition today, they would have to refile a public records request. And the statute changed. I don't know how much that's going to impact the petition here, but we will be analyzing a slightly different statute come July 1st. So a couple of things would have to happen. They would have to either rush the petition in to get it under the current statute, or we'd be analyzing a different statute. Again, I'm not sure how much that would impact this analysis, but that's something worth keeping in mind. But in a nutshell, Your Honor, correct. We would just be right back here after they filed another petition, or assuming the city denied it again.
Okay. And so then my other question is that why didn't the city, we're talking about, and you made reference to this, and of course the court believes the same thing, that it's important in this particular situation to have full, complete, accurate positions on everybody's side in order to make a proper decision here. Why didn't the city elect to respond substantively by saying, essentially, in the event the court were to find that they do have standing or could sue, then we would argue this, and this?
Well, I think first and foremost, the petitions for public records are a little bit complicated because the rules of evidence don't apply. So we're sort of just winging it as far as procedurally. Sorry, I said rules of evidence. I meant the rules of civil procedure. The rules of civil procedure don't apply. So we're just kind of winging it procedurally, in the sense that, we can't just file a 12b6 motion. So we took the position that they don't have standing, and we stand by that, in the sense that at the time we filed our response, they weren't registered. They registered to do business afterward, which again changes the position. But we didn't feel it was appropriate for the city to incur the resources where to defend this action, where no matter what the court decided substantively, the petitioner didn't have standing to sue in the first place, or access to the courts. And so it seemed to be like the most judicially economic course of action.
Okay. Thank you, Mr. Jones. All right. Ms. Kennedy, a response.
Thank you, Your Honor. We do object to the hearing being continued today. The Public Records Act contemplates prompt judicial review, and we did agree to extend the briefing out and extend the hearing out a few months in this case, to give all parties time to put their best foot forward. And the city did have ample time to brief the merits of its claimed exemptions, and it should have known what its exemptions were at the time that it actually made the denials. And so it's really had plenty of time to support its exemptions and its denials. And a continuance here would essentially reward their delay, and it would undermine the Public Records Act's goals of transparency and prompt resolution of public records disputes. But going into their actual capacity argument, EWU was just simply not required to register in Idaho. It's a national media company, and it's engaged in interstate journalism. It has no Idaho offices, no Idaho employees, no localized Idaho operations. It requests Idaho public records. It reports on matters of public concern in Idaho, certainly, but that doesn't constitute doing business. Otherwise, every out-of-state journalist or media company would need to register before requesting records or enforcing its rights under the Public Records Act. And that interpretation would burden interstate journalism, it would chill First Amendment activity, and it would create barriers to access that are just simply not found in the Public Records Act. Most media companies are owned by national organizations nowadays. Even our local papers and broadcast news are owned by national organizations. And so if we had some rule that every time you report on Idaho activities or you request Idaho records, that you have to register to do business here, that would really chill First Amendment activity. And the Public Records Act, it focuses on the records, not the requester. The requester's identity and motive are supposed to be irrelevant. And the city has really focused on EWU's identity and its business model, and that simply is improper and irrelevant to the disclosure analysis. So requiring some kind of registration requirement, it would impose a subjective analysis, and it would allow the city to look into who's requesting these records and why are they registered, or are they registered to do business here? And that simply would be another barrier that's not in the Idaho Public Records Act. But I think the court is correct that any registration issue is now moot. EWU strongly objects to having to register to do business in Idaho, but it has done so because it thinks this case is important and that the merits need to be heard by this court. And so it did not want to lose its case because of that. So any defect has now been cured. But the city's other reason for delay is that FBI letter. And we can talk about the substantive issues related to that later. But the relevant inquiry is the basis for the denial at the time of the denial. And here, this FBI letter was obtained months after litigation began. And under Wade v. Taylor, the city can't retroactively supplement its denial grounds through a post-litigation FBI letter. It still identifies no specific federal statute or regulation, and it really just isn't an exemption under the Public Records Act. It also only addresses FBI-generated records. It says nothing of these supposed Pennsylvania records or any of the other issues that are listed in our petition. And the city we understand that they've had a ton of public records requests, but on these particular issues, which are fairly finite and well-defined, they have had 10 months to identify the applicable federal law, and they've still failed to do so. So we don't believe a continuance will help that and will change things. I do want to say too, this allegation that Ms. James, that her declaration is hearsay, I would have to look at the rules of evidence, but my recollection is that public records or public documents are not hearsay. This is an official document from the state of Idaho. And Ms. James is simply authenticating it because she was the party at EWU Media that actually requested that we go ahead and get this registered and helped us do that. And so we don't believe that document is hearsay, and we think that the court can consider it in deciding that this issue has been mooted. So to summarize, we believe that the equities favor proceeding today. There is a strong public interest in timely disclosure. The Public Records Act is intended to ensure timely public access to government records, especially in matters of extraordinary public importance like this case. And the city has already repeatedly delayed this issue and hasn't really provided us a basis for withholding these documents. And we don't think that would change with a continuance. So we believe the hearing should proceed today. Thank you, Your Honor.
Ms. Kennedy, understanding, that the public records request the act and obviously the need to hold a hearing within a relatively short period of time. Other than that argument, which is still substantial, what would be the prejudice to EWU or EWU, I guess is now what I'm understanding it's probably better pronounced as from your representation. So EWU, what would be the prejudice if the court were to continue the merits hearing for just a couple short weeks?
Your Honor, I understand the court's question. I can't identify a specific prejudice that would go to EWU itself. But I would say I think the public is prejudiced whenever the Public Records Act is not timely complied with and these issues aren't dealt with in a timely manner. And so, but apart from that sort of general prejudice to the public and the lack of transparency, I can't identify for you a specific prejudice that would go to EWU specifically.
All right, thank you. Mr. James, do you wish to weigh in on this particular issue, the motion to continue?
I do, Your Honor. Thank you for the opportunity. Leander James, please the court. I'm here on behalf of the Chapins and Karen Laramie. I think both parties agree, as listening carefully, they both agree that this is an important issue and an important case. And I want to put a fine point on that with pointing out that the Idaho legislature has now amended the statute based upon this court's prior ruling in the case of Laramie et al. The City of Moscow, Latah County case number CV 29-250755, the permanent injunction case. And it is an important issue and it should be fully briefed and argued. I will add to it that I will report to the court that recently, within the past week, I've been contacted by an attorney in the state of Nevada working on behalf of a governmental entity that is going to apparently petition the Nevada courts to amend their public record laws based upon this court's prior injunction ruling. And I suspect that attorney probably is listening to me right now. And I know that attorney is monitoring this case. And I have had inquiry with others, including media, who are monitoring this case closely. So I want to address what I think are the most meritorious, as I see, argument that Mr. Jones made, and that is that he needs a little more time to reassess the city's position and to fully brief the case. I think, you know, if the balance is tipped in his favor, I think it's partly tipped because of the importance of the case that both parties agree to, and the interests can be affected beyond this case, including interests in other states. Another point that was made by Ms. Kennedy about the public interest, and her argument was that the public, anytime there's delay, there's some prejudice to the public, and I think that's somewhat true, that there would be, you know, a modest delay or could cause some modest prejudice in the sense that the public might want to know what information would be disclosed here. But there's another aspect to the public interest that the court, I think, should consider, and that is that we get it right, that we get the answer here right. The court took a great deal of time and effort and energy to analyze the permanent injunction case and to get it right. And I think we should do that here. And for that reason, I don't oppose the city's, I do not oppose the city's request for a short continuance. I think it's merited for the reasons I've said. I think it's important we get this right. I am interested to see what their ultimate position is on the merits. I do not know what it is right now. And that's concerning to me because it's going to affect my clients, I think. I'm not sure how broadly or narrowly they will interpret the permanent injunction that is of primary interest to my clients. So for those reasons, Your Honor, I respectfully request the court grant a short continuance. I don't think Mr. Jones has been unreasonable. I think he just needs a little more time. Thank you, Your Honor.
All right, thank you, Mr. James. Mr. Jones, do you wish to make any reply argument on the motion to continue?
No, Your Honor. I'll submit and stand for questions.
admittedly, I've had a lot of time, or I had time to obviously to review the briefing here, and coming into the hearing, I have had a little bit of a different position than I think I have right now, given what I've heard as far as the argument. Candidly, I was, because of this particular issue, we talk about kind of, I don't know, the gravity of it and what kind of case it is, or the implications that it would have to have these records in the public. The bottom line is that, as EWU argues, and I think all the parties agree, is the Public Records Act provides access to records for the public, so that we can ensure that individuals' First Amendment right to see, hear, and have or obtain certain things with regard to certain matters is achieved. And that is the framework for which individuals can seek to obtain those records. Really, the court is only brought into that when there becomes a particular issue, and it's really on a very limited or narrow scope as far as determining, what should be disclosed in compliance with that law. Taking all that into account, I, though, as the judge presiding over the matter, and now that it has come before the court, do feel that I'm at a bit of a disadvantage, if you will, if I do not have all of the information necessary to make an informed decision. Quite candidly, it was I understand the city's argument, the position that it took. It was a little surprising initially to not see kind of the follow-up substantive argument, to be prepared to proceed on that here today, because I think it leaves unanswered a lot of questions that, quite frankly, I think EWU is seeking, which is, what is the basis for the denial itself? What is the legal basis for the denial? And from the affidavits or the declarations that have been filed, specifically the declaration of Ms. James, that filed on March 30th, within that contains the city's responses as far to those public records requests, and kind of generally cites to reasons for denying the request. But that's really all the court has as far as that substantive part. On top of that, according to, and I think it's the declaration of, again, Ms. James, but it's the records request specifically from September 15th of 2025. I believe that is the most recent or most specific request that's been initiated to the city as far as the specific records that are being requested. But I don't have anything else to go by necessarily. So what I'm getting at is that, generally speaking, there's an argument here that, aside from the argument to continue about whether they're standing or not, there is an argument that's being made that the city's using Pennsylvania law, federal law, or other things to not disclose certain records. I don't even know which particular records we're talking about, and what that entails. So even if I were to go that direction of say we need to have substantive argument today, I would be happy to hear that argument, but I think I need more information anyways from the parties before we actually proceed to figuring out, quite frankly, what you want me to figure out, which is what information is it the whole case file in its entirety? And if it is, what does that entail? And what specifically can the city point to for saying, yes, that document was specifically, you've requested that specific document. It was created by, the FBI. Our argument is that we're not the custodian. I don't know, or it was created by Pennsylvania. Here's what it is. They're the custodian, whatever the city's argument might be. On top of that, I think I need from, like I said, I'm referring to or looking at what I believe to be the last records request again would be September 15th. I can see within that some of the city's response as far as what that entails, but I think I would also need information from Ms. Kennedy about what has EWU already obtained and what more specifically were they seeking that they did not get. And maybe that has been provided to by way of the records request. Maybe Mr. Jones and Ms. Burton are more aware of that as far as Ms. Kennedy, whether that's been, provided to them and they can specifically respond to that in a way. But I guess for my purpose in ruling on it, I'm feeling a little bit in the dark on that portion as far as what I'm ruling on. If there's a request to make a blanket ruling that the city, anything within the city's possession, that they are custodian of must be released. I think that's a different inquiry than, more specifically as to the records, each particular record. Now, I say all that because I agree that when I came into this hearing, quite frankly, I was inclined to say, no, we're not continuing it. Because I think the city had an opportunity to respond and instead chose to take a different approach and argue the issue of standing. Now that we are in this hearing and I've heard argument here, more specifically, Mr. Jones reference to the procedural posture is a little different. The rules of, civil procedure as application to this is different. And so as far as any arguments or motions, 12B6 or otherwise to dismiss, this was the state's or the city's option or choice in doing so, which is a little different than what's provided under the rules of civil procedure. On top of that, I think that there's also been more clarity as far as what the issue raised is. Mr. Jones saying the implications of if the court were to find that even if the remedy were cured or not, but if the court were to find that EWU was required to register and it should have been, should be dismissed, even though I think judicial economy may say otherwise, but regardless, even if it were to be should be dismissed, that may change the setup for what EWU is requesting. For example, do they have to then, based upon the timing of that, would have to refile a public records request, and what would that look like? And may some of these issues be cured in the meantime? I don't know. It would change the posture of the case. Certainly not suggesting that I have a decision on either one of those things, but that does change, I think, the way in which the court was initially looking at it, because by way of the briefing, it would seem to suggest that the issue was cured by the filing. And I don't, having heard from Ms. Kenny, which is why I asked, is appreciating the argument that there may be prejudice to the public I don't know that there is, given the time that has lapsed since the records request, but also, you know, setting that we've set it on a timely hearing, the parties agreed to it setting as far as that hearing is concerned. There doesn't appear to be a significant prejudice to EWU to continue the matter, understanding they've been waiting for these records for a period of time. Not suggesting there isn't any prejudice, but perhaps not so significant that a short continuance would be unnecessary. So I believe that based upon what I've heard here now in court, what I am going to do is I am going to grant a short continuance of the substantive argument. What I am going to do is consider the issue with regard to the standing, the foreign entity argument fully submitted. I will issue a decision on that. Depending on that decision, we will set the matter for further hearing. We will notify the parties. What I will do is I will set it for further hearing at this point, give you a date, and then in the event that that were to change, for example, if the court does find that the petition should be dismissed, then obviously that next hearing date would be vacated. But on an alternative, if the court were to find that the issue's been cured, should continue, then we will proceed with the full argument. And I'm going to set that for is counsel available on June? Let me just double check. June 8th. Okay, June 8th at 9:00 a.m.
I'm available.
I have a meeting if that I can probably reschedule. But if there's other unavailability, I'll jump on that bandwagon. But if I'm the only one that's unavailable, I'd like to move it.
I am available on June 8th, Your Honor.
I have no conflicts on June 8th.
Okay. So Mr. Jones, you are saying, I didn't understand. You're saying you're okay or you're not?
I'll make it work. Since everybody else has no conflicts, I'll make it work.
Okay. June 8th at 9:00 a.m. That's Pacific time. And so I'm going to ask that, I believe it's this, Ms. Kennedy, do you wish to, couple things, do you wish to advance further argument with regard to your underlying petition? Will you wish to submit any further briefing? Not required, but I just want the city to respond to your most current briefing.
I think we would want the opportunity to do a reply to whatever the city filed, like a supplemental reply. And I also, listening to the court's comments, I had maybe an idea on how we could get some clarity on what documents we're talking about. I think the court theoretically could just make a ruling that as a matter of law, Pennsylvania law doesn't apply, or there's no federal law, for example. But if the court is inclined to do more of a document by document analysis, and if that would allow for clarity, the federal courts do something called a Vaughn Index is the name of the case. And that occurs in FOIA cases. And it basically is like a privilege log from the agency, which lists out all the responsive documents and what exemptions are claiming. And for example, in this case, we know that there was an interrogation of Brian Koberger that was done in Pennsylvania, but Brett Payne from Moscow flew out there with the FBI. And so the interrogation was conducted by FBI, Idaho, and Pennsylvania. And we don't understand if that's being claimed as a Pennsylvania document or an FBI document or both. Of course, it seems to us it should be an Idaho document. But I wonder if some kind of log like that from the city would be helpful for the court and the parties. I think, would have preferred just kind of a blanket legal ruling that these exemptions don't apply, but to the extent the court wants to do more of a document by document analysis, that would be my suggestion.
All right. And I referenced, I think, the September 15th letter. Is that the most recent?
I would say for the court to look at kind of more of the specifics of the parties' dispute, I would point the court to the August 25th denial letter, and then the that September 15th denial letter. I think those are the most salient in terms of what records we're talking about, but it is confusing and it's a little vague to me on what the city is withholding.
Okay.
May I address the court?
Yes.
Your Honor, I think there's merit in the suggestion that the city and EWU creates a type of, akin to a privilege log of what documents specifically we're talking about here. For my purposes, because I may not have an interest in a lot of these documents. The graphic ones, yeah, I'm going to have an interest in them. So, if there was a list, I think it's incumbent upon the requester to identify what they're requesting first, and then, the city to identify what they're not producing. And then I don't know if the parties are agreeable to this, but if they could come up with a list, it would be most helpful along the lines Ms. Kennedy is suggesting, with a brief description of what is in the document, so we know what we're arguing over. Otherwise, I'm with the court on this. I'm a little bit in the dark about not only what arguments the city has, I need that, but I'm also in the dark as to what specific documents are we talking about and what is in them.
Right. Thank you. Mr. Jones, what's the city's position on essentially a log of?
Your Honor, that makes a certain amount of sense, and I'm sure that would illuminate things for the court. I'm not opposed to doing that. However, I would respectfully submit that 2 weeks is pretty short window to perform a privilege log in addition to the response brief. And I understand that beggars can't be choosers, but
I guess my thought was that maybe I shouldn't make assumptions. I was thinking that a log of some sort, or has probably already been created somewhere of all the things that are there, given the length of time that this case has been, not this particular case, but criminal matter had been ongoing. But maybe you need to consult with, your client about that, Mr. Jones, and determine, how long something like that might take.
yes, Judge.
Okay.
If I can say, Your Honor, I do have some sympathy for the city here. I've been notified every time they get a public request, a records request now, and there have been an awful lot. I think they're limited in their resources and they're struggling to keep up. So that may have impacted their ability to do a log at this point. I don't know.
Well, you can see the court pondering. I want to make sure that in the interest of that we only have to do this one time, I guess is what I'm what I'm trying to get to. I do think that it's incumbent upon the requester to identify what they want, which is why I was trying to, again, get to what was the most specific request that we had that was actually denied, that we need to address. And so I think there are, certain things within that list that were specifically noted, at least from the September 15th letter. It was like a supplemental, and there was specific things listed within that. There was only about, I don't know, I didn't seem like there was too many documents within that needed to be, that would take too long to address. I do know, as far as the case itself, of course, there's probably a lot to say the least. So I don't know, again, Miss Kennedy, I'm not sure what EWU has obtained or what they're still waiting for. And maybe they've gotten a bulk of that, but haven't gotten just these specific things.
Would it be helpful to provide something to the court? I mean, I think some of it is hard because we don't know what the city has. So we're kind of guessing. We're based, like the interrogation we know about because of a supplemental police report that we did get, but there could be other documents out there that we just have no idea even exist. But I could put something together for the court that lists our requests and what we've received and what is missing, or just even what's missing, or what we believe is missing. But I think the city still needs to identify that if there are any documents that were responsive to our requests that they withheld, I think that they have the burden to prove an exemption for those and maybe tell us what those are as well.
Mr. Jones, what's the position on that?
I mean, I guess the city's position would be that we're not objectionable to a log, and so the situation that I'm I can't answer without speaking to the city first is how much of a burden that will be on the city to produce a log, and so I don't know if you want us to go into a breakout room or if you want just to, I mean, we can get it done. So if you want to just set a hearing, we'll get it done. But I don't want to overburden the city staff.
Okay. Well, let's move, let's see. Could the city provide, I think let's move the hearing out so we can make sure we do this right. So can the city provide the log by June 22nd?
Yes, Judge.
Okay. And then I will have Mr. Jones, I'll have the city's response to the petition will be due, how about July 10th?
Yes, Judge.
Miss Kennedy, can you have EWU's response or reply, I guess, by July 24th? 2 weeks? Do you need more time?
An additional week actually might be helpful. That's okay with the court.
Yeah, July 31st.
That would be great.
Okay. Mr. James, as the intervener, when would you like to have, I think it makes sense you wanted to have the city's response.
Yeah, honestly, it'd be good to have both the response and the reply. I don't need a lot of time. It'd be nice to know what the reply is, but if the court, but probably the proper thing to do is just give me at least couple of weeks from the city's due date. When was that?
The 10th.
10th. Yeah, so, and I'm sure Ms. Kennedy would say, well, I want to hear what he has to say before I reply, and that's probably reasonable. So what if my brief is due the 24th?
Okay, I think that works. All right, and then we can have a hearing. Okay, what does August 10th at 9 o'clock look like?
I'm available then.
Okay.
Hopefully my client is too. She's listening. Can nod.
Yes.
I'm available, Your Honor.
I have no conflicts with that day.
Mr. Jones has something, I can tell.
I'm going to make a record of it. I have a homicide trial that is not going to go to trial at that time unless something very bad ends up happening, but it hasn't been continued yet. So, but it's going to get continued. So I propose we schedule the hearing, and I will know in early June because that's when the pretrial conference is. But if it doesn't get continued, I just bring that to the court's attention and speak with Ms. Brierton about it.
Okay. So August 10th at 9 o'clock a.m. is when we'll have substantive argument on the issue. And, I'm just going to go back to like where I started here this morning is this is not where I anticipated that we would be, but I do think that sometimes this is the way things happen in the sense of making sure that we have all the information. I think, quite frankly, for myself, but for the party's sake, so that we can figure out exactly what we're talking about and to do it right, hopefully, the first time instead of having to keep coming back to court is my hope. So I know this is going to cause a little bit of delay in the records and getting those, but hopefully even in the log itself, I'm hoping that once that's created and even provided to Ms. Kennedy, that might be even a talking point for you all to say, well, are there things that we haven't had that we can have or what it might be? I don't know. So I think it will help us move things forward actually better going forward than it would have. So I appreciate everyone's patience, as we navigate through this. So is there anything else to take up for today, Ms. Kennedy?
No, thank you, Your Honor. We appreciate your time.
Yes. Anything else, Mr. Jones?
Judge, if I could just ask Ms. Batista if she feels that her presence is necessary on that August 10th hearing. Yeah, I believe she wants to be present and she's unavailable on August 10th.
Okay.
And I hate to do that at this point.
Can I ask, is it for the full week? You could just nod. Okay. What about Wednesday, August 5th?
I have no conflict, Your Honor.
I can make it work, Your Honor.
That would work for me and hopefully Ms. James too. Yes.
That works for me as well.
Ms. Batista, does that work? Okay, all right. So we're gonna Wednesday, August 5th at 9:00 a.m. Yes, and that'll be live streamed for, I think there's maybe some folks who are listening in, so we'll make sure that that is live streamed again. Anything else then, Mr. Jones, on your side?
No, thank you, Judge.
Okay, anything else, Mr. James?
No, thank you for your attention to the matter, Your Honor.
Yes. All right, thank you. We will be in recess for today.
Thank you.